All right. Hello, everyone. This is July 7, 2026, and we are doing our first English live video. We will be answering your questions. We will be talking about new immigration developments. And I just want to mention that since this will be our first live in our new channel, there might be technical issues, so I apologize for those in advance. I am hoping that everyone can hear us clearly. Erdem Bey, can you clarify if you can hear us well? All right, we are good. And now maybe you know that I've been doing live videos for about 50 weeks in Turkish, and there was so much demand, and we wanted to do the English version as well with our attorney Leyla here. Welcome, Leyla.
Thank you so much.
And I hope that it will be beneficial for everyone because we are going through different challenging times. Everyone needs clear and correct information from licensed attorneys, and sometimes it is not possible because scheduling a consultation can be costly. So we are seeing this as an important opportunity to give community back. It is very important for us. So I hope that we will be doing these lives every Tuesday at 2 p.m. Hopefully it will be helpful for everyone.
Yes.
Welcome, Leyla, again.
Thank you so much. Happy to be here.
Thank you. So why don't we get started with the immigration developments from the last week? I know that many employment-based immigration attorneys are concerned about new EB-5 developments that I believe the Trump administration does not like the EB-5 program much, and then the administration already brought their own gold card,
right.
And EB-5 investors are kind of scared that the program can lapse. So what should they do? What do you recommend? What's going on? Can you please talk about those?
So the EB-5 program is actually scheduled for a renewal on September 30th, 2027. So either Congress will reauthorize it or it might lapse. As a result, September 30th, 2026 is a very important date because anyone who has filed their EB-5 application before that date is going to be grandfathered. And even if the program is not renewed or relapsed or is lapsed, they will have the opportunity to have their cases all adjudicated.
Okay, so let me cut you there. So let's say I have $800,000, right? And I am a Turkish citizen, and I would like to get a green card with an investment. And what happens if I do the investment in the regional center now? Or what's the difference if I do the investment after September 30th?
If you do the investment right now, even if the program is not renewed, so they take away the EB-5 Regional Program Center. The EB-5 Regional Program Center is not embedded in immigration law. The EB-5 Direct Program is embedded in immigration law. That's why the EB-5 Regional Program Center has to be reauthorized every time from time to time by Congress. So if you do the investment now, then your investment is protected. Your application will be processed if you do it anytime before September 30th, 2026.
Okay.
If the application is submitted after September 30th, 2026, and they decide not to renew the program, then we don't know what's going to happen, but you might not be adjudicated, and the investment, I don't know what's the outcome of that.
So what you say is, if I do the investment after September 30th, and if the program is not renewed, there might be a risk
Yes.
that I lose the filing fees.
Yes.
And I might not get the green card.
Correct.
Okay.
Yes.
So it is better if I have the opportunity. I feel like I have July, August, September, almost 3 months
Yes,
to
correct.
file that case.
Yes.
Okay. And you mentioned important distinction that there is EB-5 program for direct investors,
Yes.
which I can create my own company with my investment, or regional center.
Yes.
So as much as I understand from your what you said, the direct investment program will still continue.
Correct. Yes.
Okay, but as much as I heard statistically, the 95% of EB-5 cases go through the regional centers. Is that right?
That's correct. I'm not exactly sure if it's 95%, but a good amount goes through the regional centers because you need a lower investment amount, and you don't have to worry about job creation and whether after the 2 years your case is going to get approved. That when you deal with a regional program center, they provide all the numbers, they provide all the jobs. So it's much more assuring that you will get your green card, your permanent green card, when you go through the regional program.
Regional program. Okay, so the paperwork and the requirements are much more complicated if you do the direct investment.
Correct.
So if I have the enough funds that I can park for a couple few years, maybe
Yes.
I can get green card without involving the day-to-day operations of the company or creating 10 US full-time jobs, right?
Correct.
Okay.
Sometimes if you choose the right program, you get your investment back within 2 years.
Within 2 years?
Yes.
It's amazing.
Yes.
Yeah. And by the way, with the Trump's Gold Card program, there is no money getting back, right? So you kind of gift
It's a
$1
gift.
million
Yes.
to, yeah, okay.
Yeah.
Thank you for, I mean, the live is already very beneficial for viewers, in my opinion. This is very critical. Thank you for that. And we also talk about other important topics today regarding the fee increase for the naturalization applications. Can you please talk about that a little bit?
So that is a proposed rule. We're in the comment period. That means it was published in the Federal Register on June 22nd. So they have 60 days to receive comments and review it. So potentially within the next 60 days to 90 days, it is going to pass. And it's going to increase the citizenship fee for USCIS filing fee 75%, which is a very, very big increase.
So as much as I saw, the online filing fee is, how much is that now?
Right now it's $710.
$710, and it will go to $1,280.
Correct. Yeah.
All right. So I don't want to blame just this administration, because previously Biden administration, I believe, increased the fees a lot.
Yes.
However, the fee increases are, became very common now.
Mm.
And I know that, for example, employment authorization applications for asylum seekers was free initially.
Yes.
And then now they have to pay, I believe, more than $500 initially. For maybe $560, and for renewals it is $745. And unfortunately, we see that Trump's businessman perspective,
Yes.
In immigration cases.
It's not just the increase; they are also they're not accepting any more fee waivers. So the only people that are in military, they will still have those discounted fees and waivers, but outside that, they want to take away the fee waivers as well.
So I cannot even apply for fee waiver, or
No.
they do not approve it?
You can't apply for it.
You cannot apply, okay.
Yes.
That is interesting. So if I am a low-income person and I don't have the funds for citizenship, I don't have access to citizenship
Correct.
anymore.
Correct.
Yeah.
And if that's the case, I suggest that you apply ahead of time before this rule goes into effect.
To save
Yes.
maybe $500 for
Yes.
citizenship. Okay. Thank you so much for that. This was important. And another topic I want to talk about is, what is this alien registration rule and what do we know about that and what's going on?
So the alien registration rule has been in immigration law for a very long time. The new difference right now is that this administration has streamlined it. So there's an online application that you have to go and complete and then attend finger biometrics appointments. It doesn't apply to all non-immigrants because some non-immigrants are already registered. Non-citizens, they're already registered. So if you came to the US with a visa and you were issued an I-94, you're already registered. If you're here as a diplomat, it does not apply to you. And of course, if you're a US citizen, it doesn't apply to you. It basically generally applies to anybody else who's going to stay in the US for more than 30 days and is not a US citizen. The major difference right now is the enforcement. Even though it had been in immigration law for a very long time, now the enforcement is, this administration wants to enforce it more and implement it, and there can be civil and criminal consequences. And they want you to carry proof of registration as well.
All right. So let me try to understand what the administration is trying to do here. So if I am, let's say, if I come to the US as a tourist visa holder, do I have to register now?
Only if you're staying more than 30 days.
So if I am going to spend 30 days traveling across the US, going to Disneyland and other places, I have to go online on my USCIS or somewhere else?
So if you entered with a visa and an I-94 was issued to you, you don't have to register. You're already registered.
Okay. All right.
If someone is a Canadian citizen and they come in through the border and an I-94 is not registered, they don't get a I-94 issued to them, they have to come in and register if they're staying more than 30 days.
Okay, so the Canadian citizens have, if they are going to stay more than 30 days, they have to register.
And if they entered through the border and an I-94 was not issued.
Okay, if I-94 is not issued. Do you know if visa waiver program entrants are issued I-94s or not?
Yes, they are issued.
They are issued. Okay.
Yes.
So most of the tourist visa holders are not generally supposed to, I guess. So
this is mainly for people who are already in the US, entered without inspection, and they did not register. They have to register.
Okay.
And also, if you're a child under 14, you entered the US, let's say as a dependent of your parent, and your parent was an H-1B holder, you're an H-4 holder, that is considered registration because you entered with a visa and an I-94 was issued. But when the child turns 14, they have 30 days to re-register and get fingerprinted.
Okay. So I guess the main targeted community here is the people who entered the US through the southern border, and then they don't have registrations.
Correct.
And during these registrations, do they have to provide their addresses?
Yes.
Okay, so it creates real risk for them.
Correct.
Under this administration.
It also applies to green card holders, but green card holders already are registered. Anyone who's gone through some sort of immigration process is already registered. If you applied for an employment authorization card, if you have a green card, you're already registered. Okay. But if long ago this happened and you were not registered, you have to register now.
Okay, so this is mainly for undocumented people who are going on the radar, I guess.
Yes.
All right. Okay, and very shortly, the wet signature rule.
Yes.
What's going on?
So that will go into effect on July 10th, 2026.
What's that?
So right now, USCIS will accept a copy of a wet signature. So if you print the form out, you sign it, you scan it and send it to USCIS, they will accept it. If it's a stamp, if somebody puts a stamp, if you copy and paste a signature, or if you use DocuSign, those are not acceptable. If you have somebody else sign for you and USCIS compares your signature with your passport or your ID and they realize that that's not your signature, they have now, it is clear that they have two options. One is either to reject the filing and send everything back, including your USCIS filing fees. The other option, which is the difference now, is that they can deny your application even after they issued a receipt notice, which means it's considered an adjudication. Therefore, your filing fees are not going to be returned to you. And if you fill up an application that says, have you ever been denied a relief or an application, you have to say yes, and you have to explain
what happened.
What happened,
Okay.
yes.
So if I have a online version of my signature, and if I put on PDF and then print it, if they detect, they
Correct.
will deny the application.
Correct, yes.
After July 10th.
After July 10th.
Okay, this is important. All right. So Leila, I want to talk about a little bit regarding mandamus lawsuits, because our firm is kind of well known in this area, and I always in the beginning of my lives, I always explain the last week's approvals. So I think it is very important for people who have been pending for a long time. They want to hear this type of news all the time. So I just want to mention a few people. So first of all, the EAD delays. For example, we had a client from Wyoming. He had his WAVA application approved, and he had his C-31 employment authorization document. It was expired, and he timely applied for renewal. And it was almost 18-19 months. It was not adjudicated. So we filed the mandamus lawsuit in District of Wyoming Federal Court, and in just a couple of weeks, the EAD application was approved. This is such a relief.
Yes.
And another client of us was approved asylum after entering the US through the southern border, and he was a truck driver, and his CDL, commercial driver license, was going to expire very shortly, and his green card application based on asylum approval was pending for about 15 months. And we filed this mandamus lawsuit, and even though it was only 15 months, after filing the lawsuit, the I-485 green card application was adjudicated and approved very shortly. And I just want to note that it was without an interview.
Wow.
So they can interview you and they can just approve it. So they waived the interview and approved the application. And also I had another Indian client, and for Indian adjustment of status applicants, there is always a risk that the visa bulletin retrogresses. Yeah, and he was afraid of that because back in 2022, he filed a mandamus lawsuit to expedite his I-485, but the visa bulletin retrogressed and the mandamus lawsuit became moot. Now we filed another mandamus, second mandamus 4 years after, and shortly after it was approved, and during this time he was at risk of retrogression again, and I communicated with the U.S. Attorney's Office frequently so that the application was approved timely. He was so happy. And finally, we see the F2A delays more and more because the visa bulletin progressed a lot during the past few months, but they do not still approve those F2A adjustment of status applicants because USCIS has backlog a lot. Yes. And then once we filed the lawsuit for this spouse of green card holder, it was approved in a few days. They were already interviewed a couple of years ago, and it was approved on the spot after we filed the lawsuit. So if your immigration application has been pending for a long time, don't be afraid to sue the government. This is very common, and it will very likely that your application can be adjudicated if you talk to an experienced mandamus attorney, because they know the trends and when to file the lawsuit much better. All right, so
I want to make a note. This is very helpful with the EADs now, since we no longer have the automatic extensions. this kind of mandamus cases is going to be very helpful with moving those forward, right?
Definitely. So many employment authorization renewal applicants are concerned, and that rule became effective now, or
yes, it's effective.
It is effective. So we do not have any more 6 months or extension. Sometimes it was 18 months, right?
Yes.
During the Biden administration, they to make it easier for immigrants to keep working.
Correct.
They made the automatic extension for 18 months.
It was as a result of their own backlog.
Yes.
So,
yes. And now they canceled it. And
Yes.
If I lose my, if my employment authorization expires before the new one comes, then I have to
stop working.
Yes. So yeah, it was a very important note. Thank you. And so we can start answering questions, and I think we have good amount of questions for the first slide now. All right. So the first question, the person says, I filed writ of mandamus pro se without an attorney because of asylum decision pending. June 4th filed certificate of process of service. It's been a month and still no action on USCIS end. What should I do if still no action next 30 days? So when you file a lawsuit, the court issues the documents called summons. And then once you receive the stamped summons, you need to serve them with certified mail. You need to send those summons to defendants, right? And then once those arrived at defendant's location, they have 60 days to respond. Sometimes they take action in a few days. Sometimes they take all 60 days to take any action or respond to you. So it might be still normal that if you are still in that 60 days, but generally, if you know a contact from U.S. Attorney's Office, reaching out to them or taking a look at PACER records and then trying to find U.S. Attorney's Office contacts, email addresses, you can reach out to them saying that I filed a lawsuit against USCIS. Who is the assigned U.S. Attorney's assistant U.S. Attorney for this case, and then you can try to expedite the process, in my opinion. So if you file it with an attorney, they already know the U.S. Attorney contacts, but without an attorney, it might be challenging to communicate with them. Do you have anything to say on this?
I think you made a good point to sometimes that they take their full 60 days, and it is noteworthy that you can give them a nudge and you can reach out and remind them that they have to basically review your case. I think that's a very good note.
Definitely. So we generally keep track of answer due dates, and we know these people, they are our colleagues, even though from the other side, and we generally reach out to them as a courtesy, saying that, oh, your federal court answer deadline is approaching, you may not want to miss this, or the federal judge can enter a default judgment against you. All right. And another person asking in Turkish, let me translate this. So this person attended their immigrant visa interview in Ankara, Turkey, and it was the employment-based EB3 category, but I think the consulate take the case and put it on administrative proceedings because the father has stayed in the U.S. between 2005 to 2017, so it's 12 years. So I remember this question from my Turkish lives. He asked the same question there, and I told him that he has to schedule a consultation because there is a long immigration history, almost from 2005.
Correct.
And the father has left the U.S. with an advance parole while the I-485 was pending. So I think it is not easy to answer these questions during these lives because you need to see the documents, right?
Yes, correct.
So some questions unfortunately require a full document review and then full professional
Correct.
confidential consultation. All right. So there's another question here from Hector. It says, hello, for the interview, should we take all the printed documents, including evidence we sent for the I-485? Also, after how many days of sending should we expect to receive the notice for I-485 application? Do you want to take this one?
Sure. I mean, I'm a little old school. I like to take all the evidence just in case sometimes the officer should have everything. But I have been to interviews where the officer says, oh, do you have a joint lease? And even though it's already submitted, they're asking us for it. So I like to have everything with me. I always say it's better to have it and not need it than need it and not have it. That's my view. And based on the adjudications for the 485s after an interview, the officers have 120 days to make a decision.
All right. I think he was asking about receiving the receipt notice. Am I? How many days of sending should we expect to receive the notice? So how many days after sending the initial I-485 application?
Well, these days, I think I've even seen over 4 weeks for some receipt notices to come in. What is your?
So it depends on the category. For example, I filed a VAWA-based green card application, and it took them 4 or 5 months.
Wow.
But most of the time, for example, marriage-based green card applications, we are receiving the receipt notices in a week or 2 now.
Okay. Yes.
And also, as Leila said, I think it is important to take all the evidence if you have them. They might want to take look at the originals in case.
Yes, of course.
You do not have to submit originals. You can provide them with the copies. However, it is also important that if you have further evidence after you submit your application, you can take those as well.
Yes.
They would be helpful for the adjudicating officer to understand the bona fides of the case, for example.
Yeah, the originals, as you said, that's a must. Like your passport, your marriage certificate, if there's a divorce, that's a must. That everyone needs to take to the interview. But the other documents, the ones that are copies, I still suggest you have it because I've had experiences in interviews when the officer, even though it's submitted, they say, oh, we don't have it on record.
Yeah. USCIS is not the most organized agency out there, and they lose files sometimes. So it is better we have everything. And like the thing you don't want after the interview is that rescheduling another interview because you don't have certain evidence and you have to appear again.
Yes.
All right, so another question. If we submitted the I-485 while living in Texas, but we are about to move to DC, do we need to let them know in any way aside from changing our address through our USCIS account?
I don't believe so. I think it's a change of address through USCIS account or filing the AR-11 online. I guess now the new rule is that you have to file the AR-11 through your USCIS account before you could do AR-11. Yes, I don't think there's any other way.
I agree with you. So in the past, it was more challenging. Now you just go to my USCIS account, click on the profile section and update the address, and you need to put the pending case information.
Correct.
That's it. So you don't have to worry. But I recommend taking the screenshot or the PDF confirmation page and save it on your folder in case they don't move or they don't transfer your case. All right. I-612 Conrad 30 waiver approved, H-1B pending. Can I file EB-1A, I-140 now and wait to file I-485 until service is completed? Do you want to take this one?
Yes. Yes.
What is Conrad waiver, by the way?
So the Conrad waiver is for J-1s that are subject to the 2-year residency requirement. So one way to waive the 2-year residency requirement is to apply for a Conrad waiver and work for an underserved medical facility for 3 years.
For 3 years.
Yes. So yes, the potential client can file an EB-1A, have an approved I-140, and once the 3 years are over, and he or she will become eligible to file for an adjustment.
Okay, so this person is now eligible to file EB-1A and also along with the I-485 green card application.
Yes,
and
not along, but once the 3 years in Conrad are over, at that point, because he has to serve the 3 years in the underserved medical facilities.
So I've never done a Conrad waiver, but it says it is approved. So do you mean, does it mean that they have already served 3 years, or it's not clear?
No, it's not clear.
Okay.
So they get the waiver. The fact that he's applied for an H-1B, that means the waiver is approved, and he's allowed to work for 3 years once his H-1B is approved.
Oh, okay.
So yes.
All right,
yes.
Great. Thank you. How many EB-1A cases do you handle annually, and what timelines do you typically see with and without premium processing? So, Leila, I know in your 20 years of careers, you've done many EB-1A cases, and I think giving a numerical response to this question does not make sense in this regard. The trends for EB-1As are changing drastically depending on the administration's preferences, right?
Yes.
So currently we see, I mean, this is not just we, but the cumulative experience of the immigration attorneys that more EB-1 and EB-2 denials. And I do file lawsuits, for example, for final merit determination denials. So they approve for example, 6 criteria out of 10. And then in the second step, they say that, for the final merits, we do not believe that you reach this level.
Yes.
And we do file these cases. And in some of those cases, they reopen the I-140 denial. And then now they just eliminate some criteria they previously approved.
Correct.
And then try to deny on the first step. So, what do you like? I can ask you. So, do you generally recommend filing with or without premium processing, and what's your experience on that?
There are pros and cons to filing with and without premium processing. If I believe a case is very, very strong, I would generally go with premium processing. The issue with premium processing is that the officer only has 15 business days to review a case, and you give them 1,000 pages to review in 15 days. A lot of the times they like to send unfounded RFEs because they didn't have time to review it. But if it's a very, very strong case, I've done premium processing and I've been very successful with it. If I don't feel like it's very, very easy to understand, because some people do very extraordinary work and it's very hard to understand what they're doing. So if it's a case that I feel like the officer will need more time to review, I don't suggest premium processing.
Okay.
And we can always convert to premium processing. So we can start with just submitting the application the way it is. And then if it's taking longer than we expect, we can convert it into premium processing. Okay.
So your suggestions can change depending on the case.
Correct.
And depending on the facts of the certain applicants,
yes,
right?
Yes, correct.
Okay.
Yes.
Other than these, and also the immigration attorneys are reporting that they are seeing many more unfounded RFEs or NOIDs, and in some of those, it is clear that AI reviewed the initial case.
Yes.
So it is very concerning because irrelevant facts are included in some of RFEs or copied and pasted from someone else's file. So unfortunately, we see those as well.
You did say something earlier that I do think it's a good place to expand upon. You mentioned the Trump green card. So for the visa numbers for the Trump green card, they're actually pulling from the EB-1A and the EB-2 categories. So in order for the green cards to be issued, there needs to be visa numbers. And a way to do that is to deny these EB-1As and the EB-2s.
It is so unjust.
Yes.
All right. If we may have to reschedule the interview for green card due to personal reasons, how can we do that? Would it harm our process to do so? What do you think?
I don't believe it is going to harm, but it's going to definitely delay. So
maybe it might raise red flags under this administration, in my opinion, because sometimes USCIS officer can think that, oh, they did not appear for the first one because there might be some disagreements between couples if it is a marriage-based green card application. So be careful if you are asking this question, if it is based on marriage, because they are scrutinizing these cases much more right now.
And depends on what the personal reason is. So if you send a letter in from a doctor saying that either the petitioner or the beneficiary is in the hospital, that is a different.
Definitely. And also, it is, in my opinion, it is easier to get the rescheduling approved, easier for the first one. And if you do it for the second time, then it will be much more challenging. All right. Another question. Our F2A application is current. Now we are waiting for a month. When can I file a mandamus lawsuit, and does it matter where I am located? I think so. If your I-485 is pending, and if your I-130 priority date becomes current just a month ago, it can be early to file the mandamus lawsuit right now. If I were you, I would contact USCIS and tell them that my priority date became current, and I would like to ask for a status update, where my case is, what's going on with my case. And in a couple more months, if they do not adjudicate or take action, you can go to federal court by filing a mandamus lawsuit and say that your application has been pending, for example, for a year, and it has been current for 3 months, and you already reached out to agency asking for a status update because you are current now, and they did not respond to you. And if you also have any emergency factors, you can do an expedite request with USCIS saying that you have some financial obligations and they are depending on your status, or you have some any humanitarian like illnesses or family members aging you need to visit and you need this application adjudicated, then these can be good reasons for to lay foundation for the mandamus lawsuit. So I wouldn't file in 1 month, but I would feel much confident after 3 months. And it might not, in some of jurisdictions, U.S. Attorney's offices are actively fighting some delay types. For example, in California now, I-485 delays lawsuits are more challenging because USCIS is actively fighting them. But for example, in my experience in Virginia, Ohio, as I explained in the beginning, New Jersey, we filed I-485 delay lawsuits at 12 months mark or 15 months mark. We did not see any and then those applications are expeditedly adjudicated. So it depends. So we generally do mandamus lawsuit eligibility reviews for free. So if you can just send us, like, how do I show here, an email, or you can text us and you can send us your receipt notice and your residential zip code, we can do this eligibility and we can talk about our experience and whether we are feeling confident about your mandamus lawsuit. Okay, another question. How can I defend myself in interview if I applied F2A I-485 coming via B1, B2 tourist visa in marriage interview? I have lease in home country, Istanbul, I paid rent. What is possible questions after the memo? Asking because intent changed before 90 days. Do you want to take this question?
So the intent changed before 90 days. So I'm presuming that they filed. Did they file? It's hard to answer because I'm not sure when they filed the 485.
I think in that 90 days.
Yeah, so I would be way more comfortable with 90 days. But if there is a reason why the intent changed, people's intentions change all the time. So if you can justify it, I don't know what the facts. I think this needs a consultation, honestly, because I really don't know the facts of the case. But I have had cases where somebody enters on a B2 visa and their intention is to go back and they have all the ties back home, but then they decide that they can't separate from each other and they want to stay together and they don't want to leave, and they apply for a marriage-based case. So he should be ready, or she should be ready, to answer why the intention changed. And as much he does have a lease, he'd still pay rent, so he can show that he has ties. Take documents to show what happened, how the intention changed, and when he entered and when he applied for the B2 visa, that was not the intention.
Okay. So I also see that some immigration attorneys are reporting, even for the people who applied for green card more than 90 days, more than many months after entering the US on a tourist visa, they were scrutinized very detailed way, and then they were asked whether they left their job in their home country before coming to the US. Mm-hmm. So you should definitely be prepared to answer those questions if you file this in the first 90 days. And I just also want to mention that there is no written 90 days rule.
Yes.
It was a mention in USCIS regulations to Department of State regulations, and those mention even was removed. So the 90 days is a generally acceptable
enough time to change your intention.
Yes. And immigration attorneys generally recommend that based on past practices. But USCIS can still question your intent even if you file after 90 days. So make sure to explain the facts clearly. Maybe you were just visiting your boyfriend, girlfriend, and the facts changed here. They proposed to you unexpectedly here, and then you should explain that. All right. Another question. I entered the US more than 3.5 years ago. My court date keeps getting postponed. I am married to a US citizen. What's the safest way to complete this process through a green card? So as much as I understand, this person has entered through the southern border and they have a removal case before immigration court, and they cannot have their case in the court because maybe the judges are changing, or they are rescheduling the master or individual merits case. And now they are married to a US citizen and they want to adjust status, or they want to get the green card. So first of all, if you are not admitted initially to the US, if you entered without inspection, you cannot get the green card inside the US, unfortunately. We were able to get green cards approved for the people who entered through southern border, but they were given a parole document. Mm-hmm. After entering without inspection. They were kept in detention for a few days, and they were given a parole document. And those applications were approved under Biden. And during the first year of the Trump administration, I had those cases. But if you were not given a parole, there is no chance. And even if you were given a parole, I believe this administration will no longer give green cards in these situations anymore. This is my thinking. So please be your U.S. citizen spouse can file I-130 now, and you need to complete the process through the consular processing options. You have to leave at some point, and then there has to be one very clear consultation that to see if you are subject to a 3-year ban, because if you filed an asylum application and if you were here for more than 6 months without authorization, then you are subject to 3-year ban. And if you filed your asylum application more than 1 year after your entry, you might be subject to 10-year ban. And even if you go back to your home country, they can question you, oh, you filed your asylum application in the US and now you are in your back home country. Did you lie to the US government? So it will be a very complicated case. So it will not be as straightforward, definitely. And even if you go back to your home country to go through the consular processing, please be prepared to argue that the circumstances are changed in your home country so that you were able to travel back. It's not an easy process, in my opinion. Hector says, thank you so much. No problem. Thank you for joining us. And another question. So it's been already 47 minutes. I was not expecting that. I thought that the first live video will be much shorter. All right. So do they sometimes reopen previously approved EB1A I-140 cases and deny later? I'm just trying to understand. Is there a deadline for approved EB1A I-140 to file for I-485?
I've never had one of these, but I do believe it is possible. I don't believe there's a deadline on it, but maybe you can expand upon that.
So I saw some notice of intent to revoke for approved cases, whether they are I-140, I-130. I saw most of them or heard about them in most of I-130 contexts. If USCIS became aware of fraud, they can reopen the case and send a notice of intent to revoke. But for I-140, I've never heard of it.
I've heard of EB1A I-140 for a professional athlete that it was consular processing. And when he went to the consulate at the time, he was outside of the US and he did not have contracts in the US because he was waiting for his I-140 interview, for his immigrant visa interview, to attend and get his green card so they don't have to apply for his P1. And the officer argued, since you don't have a contract, you're not going to go and work in your field. And in that case, I heard that his case was referred back to USCIS for revocation. I unfortunately don't know what the outcome was or whether it was actually revoked afterwards or not. It is possible, and I don't believe there's a deadline on it.
Okay. Yeah, so is there a deadline for approved EB1A I-140 to file I-485? No. So if you if there is visa numbers available based on the visa bulletin, you can even file I-140 and I-485 at the same time if you are on a valid status in the US. Other than that, if you want to first see if the I-140 is approved, then you can file I-485 later on. And I don't think there is a deadline.
No, as long as a visa number is available. I actually, it is my advice, if there is no rush, not to file concurrently, just because if your EB1A I-140 is denied, you lose your underlying status as well. So if there is no rush and your status isn't expiring, my suggestion is to file the I-140, wait for the approval, and once you have approval in hand, if a visa number is available, file an adjustment.
Let me clarify. So let's say if I am on an H-1B visa or if I am on an E-2 investor visa, right? Status here, and I file EB1 and I-485 at the same time, I-140 and I-485 at the same time, and they deny it, and they deny the I-485 as well, but I should be keeping my E2 or H-1B status.
So
if I don't violate my status, am I right?
I believe it's a little different when it comes to H-1B, because H-1B is a dual intent visa, but for an E2, you're essentially asking them to take you out of E2 and put you into an I-485 status.
So it would definitely be more challenging to get the renewal approved, and for the current status, it might be risky.
Yes.
You say. Okay. And Erdem Bey is asking whether we should ask for subscription. So we only have, I believe, 7 subscribers on this new channel. So if you could like and subscribe, we would really appreciate it. All right. Can anyone in ICE detention file habeas, or does it depend on the certain conditions? I can take this one. So for habeas cases, your circumstances should be carefully reviewed. For example, if you want to file a habeas, if you want this petition to be filed, and if you have a final order of removal, you can only file it after 6 months of detention. So you can argue that this prolonged detention violates your rights, and it's a civil detention, it's not a criminal detention. Supreme Court said in a precedent case, more than 6 months of detention is not reasonable, so they might have to release you. But if you have a final order of removal and you want to file in 2 months, it's too early. You cannot, in my opinion, unless there are some exceptional circumstances. And if your asylum application or if your immigration benefit application is still pending, and if you do not have a final removal order, then depending on your entry, you can file a habeas case requesting a bond hearing, or you can request immediate release. So it depends on your circumstances. All right, another question. Recent stance for authorized stay status. Any deadline for authorized stay status? I-539 still pending for 7 months.
So does this mean the person has an I-539 pending and their current, I guess my question is whether they're currently in status. So the way that I would address something like this is if somebody entered the US on a B2 visa and they're authorized to stay until July 7th, 2026, and before that they file I-539, basically you're requesting 6 months, right? 6 months from July 7th, 2026. So if we're approaching the requested time frame and you still don't have an approval, you're entitled to another extension. I would file that other extension before the time frame that I requested is here.
Okay, so I initially did not understand the question, but it is very important what you said. So you cannot just keep staying here while your first B2 extension is pending, because even if it is approved,
you get only 6 months.
Yes, you only get 6 months, so you have to file another extension.
Yes, if that's the intention. If it's an intention to stay, you can apply for an extension twice. You can file another extension before, so let's say July, August, September, October, November, December, January 7th, this extension would expire. So you would have to file the second one before January 7th. And if you don't get an approval before the next 6 months, you leave.
Yes, yes, definitely. So there should not be any gap.
Correct.
Okay.
Yes.
All right. Another question from the same person, and since this is the last question, I'm going to take it. A week ago, we sent the documents from Texas for I-485, but I got a new job at DC and we have to move in 2 weeks. Would that be a good reason to reschedule the interview? Since we won't be in Texas, K-1 visa. I think if you have a new job and it is a valid reason for rescheduling, I think they would approve it. And for K-1, since I guess it is K-1 AOS, since the K-1 is approved, they believed in you, right?
Correct.
And then it's just for I-485. I think there should not be a problem. What do you think? And you are required to file the
question
change
is, when is the interview? So is it before they move or after they move?
So you just filed the I-485, right?
Yes.
So you probably don't have the interview yet.
Yes.
So
yes.
the interview will be given to you in probably Washington field office in Northern Virginia. So you don't have to reschedule it.
Yes.
So you don't have to worry.
If anything,
now.
he has to file the change of address as soon as he moves, so that the venue is changed. Because if he moves to Washington, D.C., and does not file it, then Texas will not have jurisdiction.
Yes.
Yeah.
So you only have, I believe, 10 days.
Yes, 10 days.
To file your change of address application. This is very important. All right. And thank you. And the last question. Okay, we are closing after this one. I came to USA with J1 visa, then changed my status to tourist, then F1 status. While in F1, I got married and I didn't apply for AOS. Same time, I went to jail, but case got dismissed. Marrying would be okay for me. Okay, so you already got married. I couldn't understand the last part. But if you got married and if you did not file your AOS, and if your spouse is a US citizen, and if your F1 expired, or if you violated your F1, and if your spouse is a US citizen, then technically you can apply for I-485. But please, so he mentioned that he also divorced, and then he wants to marry again, I guess. All right. So I think your case is complicated right now because, first of all, you entered with J1 visa and the memo applies to you. All right. And then you applied. If you did file if the first spouse filed an I-130 for you, they will review it as well. So they will try to understand if your first marriage was bona fide.
Well, I think he's saying that he remarried his first spouse again. Is that the case?
From my first spouse want to marry again. Okay, so if the spouse, the ex-spouse and the future spouse filed an I-130 in the past, they will look at those records. And if you marry this person again, you should be very careful. And also, the USCIS officer can see your criminal history as a unfavorable discretionary factor and can deny your application based on the last memo.
Yes, I think this is very complicated. I'm not even sure if he was subject to the 2-year residency requirement on the J1.
So if he was able to change the status to tourist, then
you can't.
Can he?
You can. I believe tourists and F1 are allowed, even if you're subject to the J1. Okay. I am not 100% sure on the tourists, but I know on F1.
F1, yes.
Yes, you can.
E2, not very sure too.
And but we also need to know the nature of the reason why he went to jail, because that'll play a big role in assessment.
Yes. So even if a crime does not make you inadmissible, let's say if it's a basic violation, it can still be used against you for the discretion, right? Even if you get a speeding, it can be used against you. Even if you work without authorization, it can be used against you. So you need to collect as much evidence as possible to show the favorable factors so that they can use some favorable discretion. But under this administration, you should be very, very careful. All right. So thank you everyone for attending. And I was expecting 35 people, and most of the time we had almost 20 people. Thank you so much, everyone. And thank you, Leyla, for accepting our invitation. How was your first experience?
It was very good. Very good.
It was very good.
Yes.
All right.
Surprisingly good.
Okay.
Yes.
So can we say next week at the same time?
Yes, we can.
Okay. Thank you. Thank you, everyone, for joining. Please subscribe to our channel, and we will put the second lives link very shortly. You can turn on the reminders, and also you can subscribe to our newsletter on our website, and we can send you reminders that way, so that you become aware once the live is there. All right, thank you again, and talk to you next week. Bye-bye.
Bye-bye.